Hi and good day everyone. Welcome to the Center for International Governance Innovation's third event in our competition policy series. And today's topic is, what steps must Canada take to address the challenges from digital technologies? And I might add, the opportunities. To briefly recap where we've been so far, in our first event, the Commissioner of Competition for Canada, Matthew Boswell, I think made an incredibly important point on why competition matters. He said it matters because a strong economy is a competitive one. Competition boosts productivity. It helps keep prices in check, and it benefits citizens, and not just some of them, all of them. And we heard of the new Digital Enforcement and Intelligence Branch that's been set up inside the Bureau that's going to keep track of evolving business practices and technologies and their impact on competition. And our panelists raised a number of issues that go beyond those raised by digital technologies, but may have been exacerbated by them, such as monopoly and monopsony power. Then the event that was held last week focused on what other jurisdictions are doing with competition policy in light of the digital economy. The European Union, the United Kingdom, the United States are all exploring how competition policy needs to change in light of the digital economy. And one takeaway from that discussion is that there may be similar issues that competition authorities are dealing with, for example, the market power of large social media platforms, but how they are addressing it varies by jurisdiction and is a combination of both antitrust and regulatory options that can place different obligations on some companies based on a wide range of factors. And it may also require greater coordination nationally and internationally among regulators. So that brings us to today. So we're going to turn back to Canada and discuss not only the role of competition policy to address some of the challenges and opportunities raised by digital technologies, but also the broader governance issues on the role of competition policy versus other policy levers and how they could or should interact. So we have three great panelists joining me today, and their full bios are available in the chat, so I'll be brief here. Keldon Bester is a CIGI fellow and an independent consultant and researcher studying issues of competition and monopoly power in Canada. He's worked as a special advisor at the Canada's Competition Bureau and is a fellow at the Open Market Institute and contributed to a very influential report, the UK Treasury's Unlocking Digital Competition, the report of the Digital Competition Expert Panel. Denise Hearn is a senior fellow at the American Economic Liberties Project and co-leads the Access to Markets Initiative. She co-authored The Myth of Capitalism, Monopolies and the Death of Competition with Jonathan Tepper, which was named one of the FT Financial Times Best Books of 2018. And then we have Jennifer Quaid, who's a CIGI Senior Fellow and an Associate Professor and Vice Dean of Research in the Civil Law section at the University of Ottawa's Faculty of Law. She's an internationally recognized leading legal expert and scholar in the fields of organizational criminal liability, corporate accountability, competition, and business regulation. And she teaches criminal law, competition law, and corporate law. So just a couple of housekeeping notes. I'm going to ask our panelists a series of questions. And as I do so, please enter any questions you may have for the panelists in the Q&A function. And we'll be monitoring those and I'll introduce them into the conversation. So now why don't we jump right in and get some perspectives on a wide range of issues from our panelists. So in the first round, I'm going to ask each panelist the same question. You've seen the first two events that CIGI had sponsored on competition policy. You've heard from the Commissioner of Competition. You've heard what's going on outside of Canada. And what are the two or three main points that you took away from those first two events? And so why don't we start with you, Denise, please?
Sure. Thank you so much, Bob and CIGI, for having me. So I thought that the commissioner's speech was excellent, and there were a few things that stood out for me. One was that, and perhaps the overarching theme for Canada, is that competition doesn't just happen. It's something that we have to choose for ourselves. And in my mind, he set up, a sort of conceptual and practical fork in the road for Canada as it looks at a wholesale update to its competition framework, not only legislatively, but in terms of the enforcement regime as well. And said that essentially this review of Canada's competition framework goes hand in hand with the drive for productivity and economic growth. And he had a real emphasis on fixing problems instead of sort of debating in circles, as he had put it. And I think that this is incredibly important for Canada. I also think that I appreciated his emphasis on the importance of stakeholders in helping choose this path forward and in setting the direction of that path. The emphasis on broad and diverse public engagement and how we define and further enable competition in Canada was really important. And I think, because we have seen antitrust conversations or competition policy conversations for many years dominated by technocrats. And, there's a place for experts, there's a place for economists and lawyers to bring their expertise to bear, of course, on these issues. But at the end of the day, competition policy affects workers, consumers, small and medium-sized businesses in very profound ways. And to be able to bring their voices into the conversation is incredibly important. And what we're seeing in the US is that there's now, very broad public engagement. One example is the FTC is redoing their merger guidelines. And the last time that they called for public comments back in 2010, I think 28 people put in, and it was mostly, highly trained lawyers and economists. And this time, nearly 6,000 people wrote in comments talking about how they had been affected by mergers negatively or positively. And I think that this is a really important part of policymaking and rulemaking. And so, I would like to see Canada take a similar path forward. And it sounds like the Bureau is encouraging that as well.
Yeah, those are really good points, especially public engagement, which is lacking, unfortunately, in many areas of policy. Keldon, why don't we turn to you, please?
Yeah, I would echo, starting with the commissioner's speech, echo what Denise said. We really do need to expand that conversation. The way our law is and has developed over the past 40 years is a product of that narrow conversation, when at the same time, we have the Rogers-Shaw merger is something that's going to affect the welfare of millions of Canadians. And so we need to make sure that not just even policy folks like ourselves are really included in that conversation. And so I think I totally agree that the FTC would be a model, especially recently, of how they've engaged with a much broader public. But I would say that the Bureau is taking incremental steps. Boswell is much more active in Parliament than previous commissioners, and their submission of the Senator Wetston's consultation, I thought was a good step to show publicly how their policy thinking is evolved. But the Bureau is still a black box to Canadians by and large, and so there's a lot of room for improvement there, I believe, especially looking to not only the FTC in the US, but the Competition Markets Authority in the UK. In the international context, one thing that I took away was, specifically for Stephen Kinsella's comments, as much as we look to the EU as a leader, they are responding to a number of things, very mechanical issues that I think we see in Canada as well. So in some ways that was heartening. Stephen talked about, overly conservative enforcement, decisions ballooning into sort of hundreds of pages, cases taking increasingly long for resolution, and not being sure if the remedies we're using are actually effective. And so it was, interesting to see that from a perspective of there's much more that we can learn from Europe beyond just these sort of big ex ante regulatory moves.
Yeah, I mean, it's fair to say the EU is incredibly active, with more directives coming out than I think Canada's put out ever, really. Jennifer, why don't we turn to you, please?
Thanks, Bob. This is a really fun conversation to have, and I think that I of course agree with the observations that have been made by Denise and Keldon, and they've made other comments too, which you should check out in the various online fora that they've contributed to. I would say that the sort of dominant sense I have, not just of the panels that we've heard the past 2 weeks, but also just in general of this this latest round of move to reform the Competition Act in Canada is it feels different. It feels, and I've been around for a long time, seen a few changes to the act in my lifetime. There's an energy here and an enthusiasm and an interest that I think was not present before, and I don't have necessarily a full diagnosis of what the causes for that are. I do think some of it is generational. I do think that younger Canadians and younger people in general are just more engaged in what's happening in the world and are less willing to sit passively by and let things happen. We've seen that in the sustainability debate. We've seen that in the discussions about inclusion and diversity, and I think it's spilling over now more concretely into what you could call the hard side of economic policy, which sort of, and I think the reason why that's important is that they're prepared to ask questions that before were just never asked. That just wasn't done. Both Denise and Keldon alluded to the fact that, this has been a very technical, technocratic space dominated by people who understand how it works. The conversations are very inside baseball. And they can be intimidating because they're often anchored in economics, and they can have the illusion, and I do insist on the illusion of sort of scientific accuracy, or that it's very complex and difficult to understand. And I think that what I took away, especially from the commissioner's speech, which I agree was, also just a breath of fresh air, was that we don't have to do things the way we've always done them, and it's time to sit down and think about what are the new challenges of this new economy. And to do that, we have to break out of old habits. We have to invite new people to the table. And we have to have other ideas. There are two other things that I would mention before we, move on. Is the other thing. The first is that despite a certain set of constituencies who persist in believing that nothing really is that different and we don't need to do that much, I think it's pretty clear from both panels. The reality of the digital economy, the digital transformation of society is there. It has real impacts. These are different from the past. We need new ideas to address them. It doesn't mean everything has changed, and I think there's room for a lot of nuance in how we look at things, but we have to understand that there are things that are different, and we don't fully know exactly the ramifications of how they'll play out. So that's the first thing. And the second thing is, it is very clear that you cannot indulge in a siloed approach to regulation anymore. So we've talked about international cooperation. That's one piece of it. But I think it's also that competition is one prong of a strategy to address the larger questions of how states seek to put parameters around the evolution of the digitization of society, because it doesn't just have economic components, it has other components. And I think one of the big questions that's being asked right now is, what's the place of competition policy in that? And does competition policy itself need to have a different footprint or a different shape?
Yeah, that's a really good point. I raised that in my submission to Senator Wetson's consultation, and we're going to turn to that a little bit later. So we'll probe a little bit more on that, Jennifer. But to pick up on your second last point, one of the way the conversation has been characterized by some groups is, well, this move to use competition policy to take on these big social media platforms, essentially, you're just saying big is bad, and I think the argument is clearly more nuanced than that. So I thought maybe, Denise, you've written a lot on, why competition policy is important, and, from a number of different perspectives. So I thought maybe why don't we turn to you and get your views on this big is bad debate, or are we populists? Being characterized in many different ways.
Yeah, absolutely. So I think in terms of the big is bad, it definitely is a mischaracterization of, I think, the very nuanced views of many people in this space who are advocating and agitating for change. None of us think that economies of scale or network effects are bad things necessarily, but they do raise new questions. And we're not saying that big is bad. We're saying if you occupy a big position, a dominant position in markets, and you abuse that dominant position, that's where the role of competition policy and other regulatory intervention is needed to ensure that you're not warping markets in your favor to the detriment of other stakeholder groups, including small and medium-sized businesses or other businesses. And it's true that with digital technologies, we have seen, increasing economies of scale and scope, network effects, as I mentioned, the aggregation of huge amounts of data. And now we're also seeing, the vertical integration of software and hardware where code, data, and compute power are leading to new kinds of moats. We've got Meta building one of the world's biggest supercomputers to be able to crunch all of the data that it has. And so, so these raise new questions. And I think one of the things that we've tried to bring up with our Access to Markets initiative in the US is that these digital firms and many others outside of strictly technology firms are essentially now de facto private regulators who are imposing terms of trade. They're imposing high tolls on markets. We recently saw, again, Meta saying that it was going to take a 47.5% commission on any digital asset sold in the metaverse. They just, they get to set those terms. And I think that Canada has had this push telling small and medium-sized businesses to go digital, to go online, without really the concurrent pillar of ensuring that markets are fair arenas for those businesses to compete. And so, we've seen a lot of gatekeeping behavior, and I'm happy to go into, more details on that. But I think just to circle back to your original question about being populist or being, big is bad, we're simply saying that markets should be governed by, fair terms for all stakeholders to be able to participate, in the gains and to compete equally in markets. And so that's the role of competition policy, is to ensure that those terms are equal and fair.
Well, since you raised gatekeepers, why don't you explain just a little bit for people what you mean by that and what are some of the concerns that have been raised?
Sure. So we've seen in the Digital Markets Act in the EU that they have a very specific definition of gatekeeper, which is, a company that has a very strong economic position, significant impact on the internal market. They have, strong intermediation position, high market cap, high turnover, large number of active users, and I think one of the panelists had mentioned in the second conversation that they're thinking about 10 to 12 companies will fall under this designation as gatekeepers. I would say that in our work in the US, we have a slightly wider definition of that, which is really any company that's acting as a middleman that can impose, again, these terms of trade, whether that be coercive contract terms or unfair contract terms that smaller businesses they're forced into this sort of take it or leave it agreement, or again where they're setting high tolls. And so that could be anything from Ticketmaster, Live Nation, or Spotify for musicians. It could be pharmacy benefit managers for independent pharmacists. It could be Grubhub and Uber Eats for restaurant delivery, or for restaurants. So any middle players that increasingly occupy very powerful positions in markets that can impose these kind of unfair terms of trade. That's how we would define gatekeeping.
Yeah, I mean, I agree. I think it is broader than just size, and we've certainly learned that in other sectors of the economy. But they, to acknowledge what I think they also said last week is that definition is fluid in the EU too. So we'll see how that evolves over time. Keldon, why don't we turn to you next? Given your area of expertise, with respect to the role of antitrust, specifically, what do you think should change or not change, based on, what we're seeing in this digital economy that we live in?
Well, I think I would go back to the comment I made earlier, as well as Denise, is that I think in Canada, antitrust or competition law has become quite narrow, and it didn't start from a particularly wide remit, but has really focused increasingly on sort of smoothing the edges on harmful activity and addressing, particularly egregious examples. And so if we think about some of those digital market characteristics, the importance of potential competition in dynamic markets, the presence of network effects and economies of scale, the idea of data as another barrier to entry. Antitrust is a very flexible set of tools that I think somewhat rarely explicitly recognizes power in markets and intervenes to either prevent the inappropriate accumulation of that power or to attempt to prevent it in the first place. If you look to the states and the incipiency standard, mergers that may generate market power, I think that's a powerful reflection of the ability of antitrust to recognize accumulations of private power and then to do something about it. And I think the problem in Canada today is that we've decided over a number of years that antitrust would take increasingly a back seat. And I think we see that in the sort of litigation record. We haven't had an abuse of dominance case in about 7 years, although we know that the Bureau is currently investigating both Amazon and Google. Those are continuing as far as we know. And when it comes to mergers in all markets, not just ones with trickier questions about the role of potential competition and upcoming competitors, the Bureau is really never successful ultimately in court. And so I think that reflects a current state where we have a set of tools that could be flexible and that could be robust, but for a number of reasons, they've fallen behind and been kind of put in the back drawer. And so when new challenges come related to digital markets, these new questions, these new characteristics, we really do need to dust off the tools. And it's an opportunity to say, well, are these actually fit to address these? Are they living up to that potential? And so I think if I had to sum it up in one sentence, we really need to expand our perception of what does it mean to foster and protect competition. And that includes raising a number of standards for what we think, I think effective enforcement really means.
Well, I don't know if I'm putting you on the spot, but I'll ask this question anyway. The one area where Canada is unique is the efficiencies defense.
Yes.
What's your perspective on this? It's a very hot topic these days. It's a particularly hot topic in one discussion taking place right now. But what's your perspective?
Well, and to be clear, Canada is unique in how we recognize efficiencies in mergers. Many other countries recognize offsetting, but our law has really taken to a focus on the quantification and sort of one-to-one comparison of efficiencies and weighing those against harms to consumers or businesses, and notably not necessarily caring where the benefits of those efficiencies go. And so personally, my bias would be to, and this is based on quite a bit of empirical evidence that says a lot of these alleged efficiencies either don't materialize or they would need to be so large to the corresponding harms that it's quite unlikely that they would be able to materialize. So first of all, I would actually like to downplay the role of efficiencies in mergers and at minimum, I get it more in line with the global perception and add a dose of skepticism on that based on the evidence that academics have been working hard to put together. But if we do keep a conception of efficiencies, I think we should take seriously the distributional element there. We can't just say, or let me rephrase that. I think competition, no matter what, has a distributional component. We are deciding where benefits are being allocated. And with that being the case, we should take that seriously and say something like, if there are efficiencies, then you need to show us how Canadians, consumers and small businesses are going to benefit from that, as opposed to it just being concentrated within existing shareholders and incumbents. So that would be sort of my two-step on that.
Well, Jennifer, why don't we turn to you, and maybe I'll ask you, the balance between, antitrust or competition law versus, well, as people call it now, ex-ante regulation in dealing with some of the issues raised by digital technologies. I don't think it's an either or, but I'm curious to get your perspective on when and how they should be used?
Well, as a lawyer and a law professor, I'm always a bit careful about terminology. I mean, to my mind, the Competition Act is a form of regulation. It's just that how it's put into place is, it requires enforcement to hold up the standards. But I mean, a lot of the work that the Competition Bureau does, and it describes this work like this is what's called an enforcement continuum. So you have a variety of activities that are brought to bear on so-called market participants, which is just the word we use for those who might be subject to enforcement. But they start with things like education and information sessions, and then there's sort of more informal discussions when companies are curious about, well, if we do this, is that okay, whatever. And it can go all the way to the pointy end, of civil litigation or criminal litigation in some cases. But at the end of the day, it is a form of modulating behavior that, in the absence of the act, there would be other things that happen. Um, but I think when people talk about ex ante regulation, they're really talking about using other um areas to modulate the behavior of market participants. And I mean, we see that already. We have lots of examples where we also regulate, for example, telecommunications companies through the CRTC. We also regulate banks. We also regulate, other sectors of the economy. I think the broader question about this idea of, what are the mechanisms by which we put limits on things. And I think, if I may just open a small parenthesis, because both Denise and Keldon alluded to this, I think it's important to understand that despite the nice idealized version of economics that is sometimes offered up, there is no perfect market, and then markets sort of left without government intervention are not necessarily superior to those that are framed by regulation. And so I think sometimes it's held out as an ideal that minimizing government intervention or state intervention in markets is the ideal we should seek, and therefore we should be very cautious about the amount of state involvement in that. And the fact is that, the evidence doesn't bear that out. And particularly in a place like Canada, where we have a large territory, a small population, and actually a lot of industries that are heavily concentrated and sometimes dominated by, large families. I We have to be careful about this dream of perfect competition, and that, oh, if we just get out of the way, the markets will just work. That it just isn't always like that. And so I think that has to inform how we think about what are we going to do to make sure that markets work in a way that benefit the most people possible. And I think that that's, important, what Keldon was talking about, the distributional effect. The purpose of competition at the moment, if we look at the purpose clause of the act, has a number of objectives that are supposed to be sought by, fostering competition. So competition in and of itself is sort of irrelevant to some extent, because what we want are the benefits of competitive markets. And those benefits are, one of them is efficiency and adaptability. One of them is, to ensure that Canada can participate in the world economy, and and as a trade dependent nation, that's important. We want to make sure that SMEs have a chance to participate in the economy. The notion of, fairly participating is of course open to discussion. And then we also want consumers to have choice and affordable prices. I think there is some question now about whether, those are the only benefits that we can get from competition, and do we need to open up what our expectations are from competition. And I think that that's, something we can certainly talk about later. Even the commissioner himself and the bureau have been studying the intersection of the economy and inclusion. They have a summit planned in September about competition and sustainability. So I think that, in the old days, we used to talk about the fact that, oh, but competition really can only talk about, hardcore economic quantifiable things. It's just not true. And I think that when we think about regulation, we think about integrating various pieces of the regulatory puzzle together. Um, we are talking more and more about a whole of government approach, where you're trying to achieve the same broad values across all sectors of government regulation. And so competition fits into that piece. I mean, what's its right space and what's its role there, I think, is something we have to talk about. But every country is thinking about, how do we respond appropriately, and how do we make sure that what we're doing benefits our citizens and our society. Because competition in and of itself, who cares? What we care is, are people better off? is our economy more productive? Are we getting the benefits, the advertised benefits of competition, or are we not? So I think that competition law, competition policy, and economic policy generally have to be held to that metric.
Well, to pick up on one of your points, in the 1990s and early 2000s, in the financial sector, light touch regulation was seen as the way forward to deepen financial markets, bring in innovative new products, deepen financial services to the benefit of many. And of course, what we ended up with was a great financial crisis. And as some people have said, where gains were privatized and losses were socialized. So this is something that we clearly want to avoid. But maybe to continue on with your last point, and it is an open question on the role of competition policy, or how competition should interact with privacy, or with broadcast. And then we know in the UK, they've said, well, we need regulators to talk to each other. And they've created this digital regulatory cooperation forum where the regulators get together and talk about what I don't know. I gather it's a voluntary mechanism, but it is something I think that that others are thinking of. And I think it comes down to thinking. Does one think about competition very narrowly, like efficiency, or does competition policy have a role to deal with some of the social issues that arise from digital technologies? And I'm not sure if invasion of privacy is considered a social issue, but I'll use that as an example. And it's a human rights issue, I'm sure. But I'd like to get everyone's perspective on this. Do you want to continue, Jennifer? Because I think you were starting to touch on this.
Sure, happy to. I think that this is where the idea of leaving aside some preconceived ideas and sort of the way we used to think about things has to just be put to one side, not necessarily thrown away. But I do believe that one of the things that we have to think about for privacy and for some of these other features that come out much more in the digital economy now is that they interact with other pieces of the what we call techno-scientific capitalism. So, these are business models that are built on some of the characteristics we've come to associate with the digital economy. So, access to data that is largely, acquired through massive surveillance. A lot of it not surveillance that people can choose to opt out of. A lot of the data is acquired on a zero cost basis, so that we are actually, providing data, and that's the price we pay for access to services. That's how the business models are designed. And these are increasingly there are questions about how all this information is put together and to what purposes it's used. So I think the lines start getting blurred. And so we might think, well, privacy is really a social right, and that's something to do with the citizen vis-a-vis the state in some cases, or the citizen vis-a-vis other private individuals, and it's not the role of competition law to think about privacy. However, when you consider that access to data is now, one of the probably the most important input in a lot of business models that are directly sort of part of the techno-scientific world, platform operators, or development of AI, for example. Without data, you're nowhere. So to sort of say that we're not going to pay attention to the fact that we're constantly mining data from citizens or from businesses without their consent, or we're constantly basically violating their privacy because it's valuable to have this information, and to say, well, we're not going to pay attention to that in mergers, like whether or not we create opportunities to go mine that data more. We're not going to pay attention to that in abusive dominance because, well, that's really a private right. I think we have to reconsider that, because these artifacts of the digital economy create value, they sustain new business models. And I'll add on the invasion of privacy component, because I've just been looking at it, increasingly labor, and so workers, are being conscripted into providing information about themselves through monitoring that then feeds the business model that is supposed to generate greater efficiency. So we end up with pieces that are very hard to pull apart. And I think the question, if I may say one more thing, is where is the right sort of either regulator or mix of regulators to address these basically combined questions that cannot be pulled apart? And I think that, there's a question, is it competition? The US is definitely going that direction. They say, look, FTC and the DOJ are probably the best positioned to do this. Europe may have a different approach. So I think that we need to think about it. These are not going to be nice, neat little questions anymore. We have to get our heads around the messiness.
Well, there's a comment from one of our listeners that IoT devices, which have no security around them whatsoever, they're pervasive in our house and outside of our house. I think most people don't even realize that they're huge data sucking machines. And the person asks, how would IoT actually force data and privacy and competition and whomever these regulators to get together? I guess one could say we hope so. If countries even have those bodies in place, we don't have a data commissioner in Canada. But why don't I turn to? I'll go in reverse order. Well, Kelvin, you're in the middle, so why don't we go to you next and get your perspective?
Sounds good. Well, first off, I would say I think there is a narrative that competition is being asked to solve all the world's problems, and I think that actually avoids a tougher question, at least in Canada, which is, well, are we even doing a particularly good job of that narrow, of the narrow goals that the competition policy and law allegedly have? We have very high levels of concentration. We have markets that have quite poor outcomes in terms of things as boring as price, and so I am a bit skeptical when people say we're trying to solve everything, when we really can and should be starting with, are we doing a good job with the initial agenda, and then thinking about, well, how can we expand that? And what I would say is that competition law and policy, I think, can be very flexible as things become vectors of competition. So to the extent that privacy is something that consumers or businesses compete on or look for in their business, we can incorporate those factors, and that would go to my second point, which is the complementarity of competition law as it is, bringing cases, investigations, and regulation. Competition law is, to me at least, it's a process of discovery, and sometimes that process takes too long for some people's liking, but it really is a process to unearth a set of facts about a specific situation, and that can be really valuable. I go back to the Rogers Shaw case. We've only had a handful of documents released, but already we have this really rich public record about Canada's telecommunication market that we didn't have before. But the flip side of that is, and I referenced it when I said how long it can take, is that when you have a more concrete set of behaviors that you no longer find desirable, that discovery process and case by case basis can be less effective. And so I think in situations where two criteria, the further away from the competitive process, which I would include unfair and fair business practices, the further away from that process the thing you're worried about is, and the more concrete the topic is, the less need for that discovery, the more there's a role for regulation as opposed to competition law. Although I agree with Jennifer, the Competition Act is a piece of regulation, but that aside, I think that framework is helpful.
So Denise, one of the questions that's come up is, and I'd like you to answer the question too, but I think as you answer it, there's a question like, why should a small business even get involved in trying to influence the direction of competition policy? Which might seem like a very overwhelming, I think, thing to try and even get involved in. But maybe as you answer, the question on like, How should competition policy address, or should it address various other types of issues? How would it take this into, like, how would a person get involved or a company get involved?
Yeah, sure. Happy. Maybe I'll park that one and return to the first question first. So I felt like Jennifer was reading my mind or looking at my notes because she underscored so much of what I also wanted to share, which is that competition matters by their very nature are social issues and social concerns. How markets are shaped, the rules governing them, to state what should be obvious are matters of public policy, and therefore markets are public creations. And I think this idea of laissez-faire, free markets, unstructured markets, there's this fantastic essay that was written in the 1970s called The Tyranny of Structurelessness. And it makes the point that when you have a vacuum of formal structure, inevitably informal structures and power structures form. And so when we abdicated rulemaking away from the public and away from democratic channels in terms of how we structure markets, basically we had the largest, most powerful actors setting these rules in their own self-interest. And so the idea that we can somehow silo competition policy to narrowly focus it on economic concerns, which of course are also social concerns, is it's magical thinking. And so I think to underscore what everyone shared here, that doesn't mean that competition policy is a cure-all. And when we think about the intersection of it with things like privacy, I remember even a few years ago talking to people about privacy concerns, and people sort of thought like, well, I don't have anything to hide. Amazon Alexa in my house, it doesn't matter. They're not going to get anything too damaging on me. But what I think that people now are starting to realize is that the aggregation of that data is not just for some distant purpose. It's now being used and weaponized against you for hyper dynamic personalized pricing. So you're going to be paying more because the tech companies know the price elasticity that you have, and they're going to hit you at the very, very top of your of your ability to pay. We're seeing that with newspapers. Vas Bednar has done some great writing on this recently in her newsletter Regs to Riches. So we're seeing this, that data is now being weaponized not only to charge you more, but also to influence your political, perceptions and whatnot. So I think privacy, and competition matters are so completely intertwined with these questions of shoring up democracy, of ensuring that markets have fair pricing, the transparent pricing for consumers. And then when it comes to, the same is true for businesses. If you're a business on Amazon, if you're a third-party seller, they have all of your, most sensitive competitive information. They know who's buying your product. They know which of your products is selling well, what color. And of course, we've seen many instances where Amazon Basics rips off one of their third-party sellers and undercuts them in price, and makes it very challenging for small businesses to compete. So why should small businesses get involved? Well, through our Access to Markets initiative, we've talked to hundreds of businesses across the country in very, very diverse industries. Some of them, rightfully so, don't want to go on the public record because it's very intimidating and they fear retaliation. But some, the few that are willing to do so, have found one, that they have found the others. So they've found a lot of alignment with even very diverse businesses who are experiencing very similar challenges, that they can find some common ground and common language to express their challenges. And they're seeing that regulators have a deep interest in hearing from them. So the FTC has been doing public listening forums by sector, hearing from entrepreneurs and investors, actually, who are saying, please do something about this because I want more investable opportunities. The market is so concentrated and there's nothing interesting to invest in anymore. So I think there's space for everyone to get involved in this conversation, and and it really is incumbent on us to participate because again of the. And I guess the last thing I'll say is you asked about the populist question. And I think, if competition policy means solving problems for real people, then feel free to call us populists all you want. But, that is the aim of what competition policy is here to do. It's not competition for competition's sake, as Jennifer said. It's to achieve these other broad outcomes about how we want to see the Canadian economy thrive, how we want to see businesses thrive, how we want to see workers thrive. And I think that's an incredibly important part of this conversation.
Well, we have some interesting questions here, and I'm going to throw them out and see if anyone wants to address them. But one of them is the way it's phrased is competition policy versus trade policy. Do you think there's trade-offs there? Yes or no? I mean, the efficiency defense in part is about encouraging companies to scale so that they can compete on the world stage. But anyone want to talk about that particular aspect?
I can just say that the rationale behind that idea, and then I'm sure Keldon has things to say as well. The rationale that you somehow have to tolerate concentration, but also perhaps supra competitive conditions locally to allow your national champions to compete in the world, it doesn't bear out on the empirical evidence. So if you want strong companies abroad, they should be strong at home, which means they should be fighting for their competitive place at home. So there is a little bit of a kind of a, I would say, a fairy tale about why the efficiencies defense matters so keenly and why we have to have this particularly special one that makes it that basically gives efficiencies a much more significant place than it would in other countries. Other countries take into account pro-competitive effects, but they don't isolate them in a second step in the process. So I think that we have to be careful about somehow thinking that we have to put up with less than competitive conditions at home so we can compete abroad. The other thing I would say is that for better or for worse, the trade system didn't integrate competition or a specific clause on competition, at least in the last round of WTO. So there is maybe some room for discussion about congruence between those two things, but I don't think that trade is an argument that can be used to sort of undermine efforts at strengthening competition policy, and it's certainly not the case with our peer jurisdictions as they move ahead. Will we need conversations about trade? Probably, but I don't think you can hold up trade as some sort of thing that we need to worry about that would prevent us from improving competition policy.
Yeah, Statistics Canada had done some very good work that shows that that firms that engage in international trade are ones that become productive at home first, and then that allows them to enter international markets. Keldon, I think I cut you off there. What points would you like to raise?
No, not at all. And I'm certainly hopeless on the trade file, but I would just add that the elements of our law that were initially supposed to support that export development have now grown and are applied to companies that will never export and to areas of the law where efficiencies weren't even envisioned to be contemplated. And then the second point and this is more general, is that we also didn't build in the ability to see if anything actually worked. So whether efficiencies are actually recognized after we accept those arguments, we really don't have a view on that, other than the limited academic literature that says actually they usually aren't realized and the productivity benefits aren't there.
Denise?
Yeah, I just wanted to make 2 points. One is that there was a period of time where decartelizing industries was seen as a way of liberalizing economies to be able to have them participate in global markets. The most notable example being World War II, post-World War II in Germany, where the US and other European nations took a very explicit approach to deconcentrate the industries to have them participate, to create a sort of economic liberty within the country and to have them participate in global markets. And I would also say that, in Canada, the thing that I always find hilarious about this conversation is that many of the industries that we're talking about that are highly concentrated are not globally tradable goods. So there's no reason to assert that we need national champions in telecoms, as an example, or in funeral home services or any of the sorts that are not traded globally. These are local monopolies, local oligopolies, and and so I think that argument, of course, it has implications for national security and specific industries, but we have to get much more specific about, what we're talking about when we raise that sort of straw man argument about, the intersection of competition and trade policy.
There's another question here which relates to the role of standards, and it's one of those things that ubiquitous. There's standards around everything, but we don't really acknowledge the importance of standards. And they're one of the biggest. Standards help create level playing fields, and they also encourage help trade as well. And so the question is, I think the EU has just adopted the USB-C as a common standard for phones. And do you think this kind of standardization is a good idea? I think I've already expressed my bias, but I'm curious what the panel thinks.
I
Okay,
would just
Calvin,
jump
you
in.
look like
I'm
you're
really
almost
not
about to talk.
sorry.
Yeah, go ahead,
am
please.
I on?
Yeah.
For the USB-C thing in particular, I don't. That wasn't on my top 10 wish list. What I think about, at least in the competition context, and related to discussions, particularly in the UK, but also related to the Digital Markets Act in the European Union, is codes of conduct, in as much as those could be considered a standard, and where that is in the competition sense, the equivalent of saying, we have a set of behaviors that we see in market that we want to address broadly. I think, restrictions around self-preferencing is a great example of this, and also relevant in the legislation working its way through in the States, is that we set a standard for what we think fair and unfair competition is, even if we don't use those terms. So in terms of true technical standards, I'm less sure of that. But when it comes to outlining codes of what we believe to be fair and unfair practices, I think we should be less hesitant about that, specifically in Canada.
Yeah, I've said that we need standards around what are referred to as standards by some of these companies. We're kind of running out of time, and I did want to ask each of you one specific question. And that is, if you had to see one change, but I'll give you two if you want, to ensure that the Competition Act remains fit for purpose in a rapidly changing digital world, what would you throw out there? Maybe we'll start with Jennifer.
That's a tough one. Just one.
I can give you two.
I guess.
You have time for two.
Yeah. It's always the debate a little bit between the specific and the general here. So, you can get down into the weeds on the technical changes pretty quickly if you want. I think what I would like to see is attention paid to greater attention paid to the effects of anti-competitive behavior and to the distributional effects. So I don't know whether concretely, that means that we mandate a different way of looking at pro-competitive benefits, that we say that pro-competitive benefits are not just aggregated. Canada applies a total welfare standard, which just means, is the pie bigger? Many other countries apply a consumer welfare standard where they say, well, what slice do consumers get at the end? There are criticisms of that approach as well, but that is something where you pay attention to, some distributional aspects. Do we need to pay attention to, the slice that workers get? I think that probably that's one thing. And then I think the other thing that I really hope is achieved in the short term, I'm going to not talk about technical amendments. I have plenty of opinions about that. But the other thing I think that is absolutely essential is that this government and governments in countries everywhere have identified some key priorities that are like sort of trans society objectives. And this government has identified sustainability and inclusion as one of them, a reconciliation with our Indigenous peoples. And I think that if you care about those big goals, you've got to bring to bear all your policy instruments on that. Does that mean you're solving those problems only with competition law? Of course not. But it does mean you need to keep those in the back of your mind when you're looking at what mergers do you approve, what kinds of conduct are problematic and for what reasons, and to think about how you might bring economic levers to bear on the achievement of those goals. Because at the end of the day, and I've said it, Denise has agreed, Kelda, it's about what competition and what economic policy brings to us as a society. Are we better off? That has to be the metric. And I think for a long time, far too long, competition policy has put the emphasis on predictability and keeping it narrow and neat. And I'm like, we need to embrace the messiness.
Well, a lot of nodding heads here. Keldon, why don't we get your perspective, please?
I think answering the question of how do you stay fit for purpose as things change rapidly around you, maybe this is an overly nerdy one, but I think the Bureau's ability to gather information, not only about its own actions and inactions, but changes in marketplaces, I think is a huge gap that we have. And I think it always just puts us on the back foot is that our set of laws are always or our enforcers are always playing catch up. And we really do need to understand the effectiveness of our tools, what we've actually been doing for the past 40 years, has it been working? But I think even beyond that relatively narrow retrospective angle, that kind of insight and view in other countries has led to really competition informed legislation that's outside of the remit of the competition authority, but is informed by that investigative and fact finding approach. And so in terms of staying relevant and staying effective, I think you really need to focus on your ability to gather adequate information, because correctly we've shifted our emphasis to data informed policymaking, but we've forgotten that much of that data is locked up in private corporations, and we need to take seriously, not just in competition, how we actually access that data to make that informed policy, as opposed to just having to rely second or third hand.
There is an irony in this era of big data that there are, well, in some cases rightfully so, restrictions on accessing data, but one would think that our Competition Bureau should be able to get access to what they need. Anyway, Denise?
Sure. So my number one wish list item is the removal of the efficiencies defense, which Keldon spoke to earlier in the Act, and both for mergers and for the section on agreements or arrangements that prevent or lessen competition substantially. We've had previous Commissioner John Peckman has stated that the efficiencies defense is, quote, bad for business and bad for consumers. And it's also out of line with the approach being taken by many of our country's major trading partners, including the US. These provisions were added in 1986 and I think reflected this kind of devolution in antitrust enforcement principles that was happening in Canada and the US, of that kind of narrowing the scope to simply thinking about efficiency as the highest public good, and this adoption of the kind of consumer welfare standard where the narrow focus on pricing and low pricing for consumers kind of trumped any other concerns. And to Keldon's point earlier, we know that even with this narrow explicit focus, the enforcement of the Act under the auspices of the efficiencies defense hasn't even met its own objectives. And there's an academic in the US named John Kwaka who actually reviewed over 3,000 mergers and found that when mergers led to 6 or fewer significant competitors, prices rose post-merger in 95% of the cases. And so, these efficiencies, these so-called efficiencies that are supposed to be passed on to consumers, predominantly through the mechanism of low pricing, is not happening. And so I think that if we remove the efficiencies defense entirely, it opens up a green field of thinking, to Jennifer's point, much more broadly, much more expansively about the role of competition policy, what we want it to achieve for us. And it also gives the enforcement agencies the ability to take on cases and not have to sort of use these highly econometric arguments to prove their case. They can use, lots of different types of evidence to show abuses of dominance, both indirect and direct, that I think would have a major impact in terms of our ability to enforce competition policy in Canada. So that would be top of my wish list.
Well, I think we're going to end on that note, and that may be a provocative note for some, but I think it's a good place to end. So let me thank our panelists for their insights. I learned a lot, and to everyone out there, thank you for listening in. This session has been recorded. It will be on our website with the first two events. And more generally, if you'd like to keep up with what's going on CIGI, at CIGI, please subscribe to our weekly newsletter, which you can also find on our website. And I think the link was put into the chat. So once again, thank you very much, everyone, and a good day.